Friends, in the previous episode, we mainly talked about the way semiotics is to be understood. We also talked about how technical language will be different from ordinary language and how poetic language is different from ordinary language. Now, we are going to go into this technical language aspect in greater detail and with special reference to what is called legal language. We have already said technical languages, including legal language, mainly depends on definitions. Every term will be defined. As I said, child will be defined, marriage will be defined, fraud will be defined, composure will be defined, death will be defined, murder will be defined, homicide will be defined, everything will be defined. You cannot say such and such a dictionary says different things, that is all right. This act says this is dowry, period, and court will go by that act. That is very important. Because it is definitional, it actually is a very peculiar thing. Clarity as well as precision, both are important. Clarity as well as precision is not going to be proverbial type pithy expression. No, there will be enough of clarity, there will be no room for ambiguity, confusion, fuzziness. So, precision and clarity. Because these meanings are definitional in nature, such technical documents can be translatable, can be translated. This translatability is a very important criterion for technical language. It is not bound by the particular word used in the act. For example, the word dowry. In Telugu, we can use the word katnam. There is something called ole, what the man pays to the girl's parents to marry the girl. If for some reason English does not have a word for it, they may borrow the word into the act, or they may clearly say reverse dowry and define it, or define dowry to mean both. If, for example, domestic violence, violence on the wife by the husband may be at one time the definition, but later either judge-made law or by amendment of the parliament, it may include violence committed by one spouse on another. That is how things go on changing, and it will be defined like that. Domestic violence may not include violence on the servants. It may deal only with wife, but later it may include servants, it may include daughters-in-law, it may include mother-in-law. What do you mean by it may include? That is how definitions change, and suddenly they say amendment on the definition of domestic violence main sentence, then rest of them follow, because the violence, perpetrator, victim, they continue to be the same. That is how definitional values become important, and that is where translatability becomes a very deciding factor, because any sentence which is not translatable can be construed as non-technical. No, this is not technically worded, because it cannot be translated. I mean, we are putting the whole thing other way. A technically accurate sentence or a sentence in a technical document can be translated. Anything which cannot be translated is not part of any technical document, this kind of thing. Technical language, we said, allows translation. There is an expression here, allows translation without residue, without anything left over. No, we cannot talk about it. No, not in legal documents. In legal documents, no residue will be permitted. Even in a document in physics or chemistry, no residue will be allowed. You have to translate it totally. All the definitional values should be recaptured. It shuns individual variation. Technical language shuns individual variation. You cannot say, no, in my understanding of physics, incident does not have that meaning. No, not permitted. You cannot say, in English this word is there, we do not have this concept. No, in science there is nothing like concept of English, concept of Russians. Incident, matter, light, weight, all these things should be defined. If there is a term called heavy water, heavy will be defined in terms of heavy water, not heavy bag or heavy suitcase. Heavy water is different from heavy bag and heavy suitcase. That word heavy will be translatable. Which word will be chosen in that given language is a different point. But you cannot say, no, I cannot translate to Telugu, I leave it. No, you cannot leave it. There is an interesting thing here. How come this translatability is coming up everywhere? And how is it taken care of? It is taken care of because on the following, for the following reasons, or the following factors take care of it. Technical language use minimizes dependence on co-text and context. Co-text is another word or another sentence in that same document, co-text. Context is the context in which it is used. Again, to go back, the word child will mean child as per the definition, not as per what comes in the 5th clause or 6th clause or 7th clause. Child is defined and child is defined. The word incident in physics is defined. Osmosis is defined. So, it does not depend on another sentence in the paragraph, that is co-text, nor does it depend on the context. In the morning is one thing, when women are around another thing, men are around one thing. No, technical language does not allow individual variation, it does not allow dependence on co-text or context. Legal language, as one of the important aspects of general technical language, is again totally dependent on the way technical terms are, the legal terms are defined. Here, I give you a few examples. Some words are primarily legal. They are used only in legal contexts, maybe a document, maybe a judgment of the, a document like a statute or a document like the judgment or discussion in the court. I will give you 3 words: estoppel, tort feasor, plaint. These are all primarily legal terms. That is, they won't be used generally in any other document, unless you find a legal document prescribed as a lesson in English textbook. Then you say, no, sir, this is part of the English textbook. Yes, it is originally a legal document. This I found recently, totally chemistry material used as a lesson in a book. And then the word pitchblende is used, not properly defined. That is a technical term. That is the ore from which both uranium and radium are obtained. So, that kind of technical lesson, if it is prescribed in English textbook, does not become this non-technical. You may study it in a general way, but that does not nullify the original claim. The word estoppel, tort feasor, plaint are legal terms. Tort feasor is one who commits tort. Tort is a civil wrong which can be paid for. You pay damages for the wrong you commit. T-O-R-T, tort. And etymologically, words like torture come from the same source. And feasor is very interesting. Fees is from Latin facere, to mean do, to do. Feasor is doer. But you look up a dictionary, ordinary dictionary, you won't get the word feasor. You get good dictionaries, they will use the word in law and then say someone who does, someone who commits. Tort feasor is one who has committed a tort. A plaint is the document you submit as a complaint against someone. Estoppel is you are told not to go back on your original statement, estoppel, from where the word stop comes. There stop will not be a technical term, estoppel is technical term used in English. There are certain words used in regular language, but they are used in legal documents with a separate meaning. I call them secondarily legal documents. Determination of the case, that is conclusion of the case. A written statement, for us anything is a written statement, that is a reply to the plaint. There are certain words which are tertiarily legal. These are the words which can be part of social discourse, but they are not. One meaning which fascinated me was unmeaning. To mean is a verb, meaning is the process of meaning something, unmeaning which cannot mean anything, become, becoming, unbecoming, mean, meaning, unmeaning. Generally we do not use it, but this is used in legal documents sometimes. Our own Indian Evidence Act 1872, they use it, there it is used. This unmeaning is like unbecoming, I told you, having no meaning or not intelligible. I quote deliberately from Indian Evidence Act to show how it is used. Section 95 Indian Evidence Act. Evidence has to document unmeaning in reference to existing facts. When language is used in a document, is plain in itself, but is unmeaning in reference to existing facts, evidence may be given to show that it was used in a peculiar sense. That is why I was saying, though legal documents do not refer to co-text and context, there are some area I said unmeaning is the word. Estoppel and tort feasor are pure legal terms. Estoppel means a conclusive admission which cannot be denied by the party who it affects. interesting thing is already defined legally, whereas unmeaning won't be separately defined. That is how technical terms acquire clarity and precision. There is a plaint, first document, complaint. The plaint says that the plaintiff submits that the said amount of rupees 15,000 was lent and advanced by the plaintiff to the defendant at Nasik, where the defendant executed the promissory note in favor of the plaintiff, and the amount of rupees 21,000 within brackets rupees 15,000 the principal sum and rupees 6,000 interest thereon is due and payable by the defendant to the plaintiff. You may say, the other man can say, sir, it is all full of lies, I do not agree with it. No, legal document cannot say full of lies, sir. What do you mean full of lies? What is the lie there? What is not lie there? Now, the defendant gives back a reply, and that is called a written statement. I told you this is a technical term. With reference to para 6 of the plaint, the defendant denies. And look at the denial. Look at the denial. Denial is not for the whole sentence. Denial is for every constituent of the sentence, for every ingredient of the plaint of that paragraph, every ingredient of that sentence in the paragraph. With reference to para 6 of the plaint, the defendant denies that the plaintiff lent and advanced the said amount of rupees 15,000 or any part thereof. Now, look at this, said amount of rupees 15,000 or any part thereof to the defendant at Nasik or at any other place, and the defendant is denying. The defendant executed a promissory note and or receipt thereof is denying in favor of the plaintiff at Nasik or at any other place or places, because he does not want to leave any doubt. Oh, well, not really Nasik, it is Triambakam, it is Pune, it is Aurangabad. No, Nasik or at either place. The defendant further denies that the amount of rupees 21,000, that is rupees 15,000 the principal amount and rupees 6,000 interest thereon or any part thereof is due and payable by the defendant to the plaintiff. A common man says, sir, what is this? He can say, I deny everything he has said. That does not work, because we do not want to leave any chance to the other person. So, you did not, what do you mean by deny everything? Do you deny my existence? Do you deny your existence? No. You deny what is said in the plaint and the different ingredients of the plaint. That is how the legal documents become complex. There is something called plain English movement, because people got angry. They said, what is this nonsense? I mean, legal documents are becoming so problematic, we can't understand what is happening. And they impute motives. The advocates and the judges would like us to be in ignorance so that they could exploit us. That will not really cut much ice, because it is a technical document. Yes, wherever clarity can be brought in by replacing one difficult word with another or phrase with another. If, for example, if we said is tantamount to, you can replace it with amounts to. No legal value is lost. It is not a definitional term. Is tantamount to is not a definitional phrase. It is equal to, amounts to. That can be done. So, what the plain language people say is, plain language movement, they say please prepare your documents in such a way a common intelligent English knowing fellow or whatever be the language can understand it, not get bewildered or confused. Plain language is the appropriate and correct. It does not say plain language is the correct use, appropriate, appropriate to the subject, appropriate to the context in the sense it is a contract, it is this, it is that. It should be clear. It is a document dealing with rental, leasing a property or buying something, selling something. So, the document should be clear. Appropriate and correct use of the full vocabulary. You cannot take anything for granted. You cannot say, sir, man includes woman in general sense, because we say man is mortal, so woman also is mortal. No, man or woman, you bring in both. Adult or child, include both. Full vocabulary in well structured sentences following established rules of grammar. No one is asking to flout rules of grammar. Plain language is language that is free of jargon and chosen with sensitivity to the needs and prior knowledge. That is, the users of the documents should understand. I remember recently an advocate asked me to read a sentence of Dr. B. R. Ambedkar in a passage he wrote in 1953. When I explained it, he said, now I understand, sir, because the very structure was difficult for him. There is no legal point involved. It is a complex sentence. This man's knowledge of English was not that good. So, it is not a legal point. So, that kind of complexities can be ironed out, but the complexity of the structure is due to this very nature of the subject. You cannot question. Here, some people talk about golden rule of legal interpretation. What is that golden rule of legal interpretation? The grammatical and ordinary sense of the words is to be adhered to. Mind you, there is no full stop there. That is very important to note. You cannot say that the clause is complete. No. The grammatical and ordinary sense of the words is to be adhered to, unless that would lead to some absurdity or repugnance or inconsistency with the rest of the instrument. Here instrument is the document, legal document, in which case the grammatical and ordinary sense of the words may be modified so as to avoid that absurdity and inconsistency, but no further. Your interpretation should not be repugnant to the total legal values. Two more points, I will be doing it, about rendering a legal document into a plain language legal document. A person, this is the original version in English, but legal English. A person must not in the course of a business enter into a timeshare agreement to which this act applies as offerer unless the offeree has received together with a document setting out the terms of the agreement or the substance of those terms, notice of his right to cancel the agreement. A revised version, especially the person was referring to the words offerer and offeree. Before a seller enters into a timeshare agreement, he must give the customer a right to cancel, notice and a document setting out the terms of the agreement or the substance of its terms. Very simple thing. But look at this, such a word order may be considered more difficult to process than a sentence in which its constituent parts are in chronological order. By saying before, there you look at this, a person must not in the course of a business, in the revised version says before a seller enters into, and also one should not forget seller and customer are not the same as offerer and offeree. Customer may be defined in different ways, offeree will be defined in one particular way, the one who is offered. It may not be a selling thing, it may be something else. So, offerer and offeree have specific values which seller and customer cannot capture. John Brigham now talks about interesting comparability between legal language and natural language. Actually, some of the judgments of Supreme Court judges and even High Court judges, when some by the way statements come after dicta, they are very common expressions and with lot of values. John Brigham says, at the highest appellate level, that is Supreme Court in our case, at the highest appellate level, the legal language ceases to be wholly tidy and takes on the characteristics of the ordinary use of language, because there human dignity, human values, all these things are discussed, policy decisions are discussed, the way human beings are thinking differently. See, Supreme Court judges have a little more freedom when they write their judgments. A sentence like poverty is no crime, I think it was from Justice Krishna Iyer's judgment on something, that kind of thing is no longer legal. It is more of ordinary use, or you may say even it is like poetic prose. Thank you very much. We have had a reasonably good coverage of ordinary language, poetic language, technical language in general and legal language in particular. Thank you very much.